is a great question. Rob Adams asked me on Quora. If someone trademarks my personal name, does that mean things bought or registered under my personal name, the name in my birth certificate, can be claimed by them? I'm Andrei Mincov, the founder of Trademark Factory, and here's my answer to Rob's question. No, of course not. That's not what trademarks are for. That's not what trademarks do. What trademarks allow you to do is to stop anybody out there from using the same or similar brand to sell the same or similar products and services. It doesn't give you the absolute monopoly over the brand. It doesn't give you the absolute monopoly over the name, the logo, the tagline, whatever it is. And it certainly doesn't give you the absolute monopoly over personal names, right? A trademark, like for example, if you're a celebrity and you trademark your personal name for particular products and services, yes, if somebody else has a similar name or the same name, you can prevent them from going to that business because you have trademarked it. But just because you own that trademark does not mean that they have to stop existing. It doesn't mean that they have no property. It doesn't mean that they have no rights. Your trademark is your trademark. That's it. So just like your personal name doesn't give you any rights in their trademark doesn't give them any rights to your other property. All right, here's a question from Zelda Smith. She asks on Quora, do you have to have a trademark name in order to test out a business prototype? No, you don't need to have a trademark name to test out a prototype. These things are completely separate. What it probably does mean that it's a good idea for you to protect the name if you believe that there is potential big future for the product behind the prototype. It's just common sense, right? It's a lot easier to protect the name when nobody has heard of it, when nobody has seen what the product is going to do, and during the prototype stage, you're just trying to figure out, is it something worth pursuing? So with trademarks, the when is, it's often too late, but never too early. But is there a legal requirement for you to have a trademark before you do the prototype? No. Is it always a good idea? No. Because, again, sometimes you don't even have a name for the product when you get to the prototype stage. But if you are already a known company and you're just about to release a new product, maybe that's a good idea to give that product name, trademark it, and then do the prototype. But again, all of this boils down to a few things. A, if you don't have a name for the prototype yet, don't worry. Take care of the product. If you have the name that you're kind of thinking about, but you have no idea if this prototype is going to work, you might wait a little bit and see how it behaves, how it works. And if you know that you've got a great brand and potentially a great product, that you're just being at the prototype stage now, but you know for sure that this is going to be big, then yes, protect it right away. All right, Sue White asks me on Quora, does an EU trademark cover trademarks in the United Kingdom? As of me recording this video, the answer is yes. UK is still part of EU, and EU trademarks will cover UK. When Brexit finally happens, there's different possibilities depending on how the Brexit is going to be accomplished. There's always some new updates one way or the other, but there will be some transition and there will be some mechanism of recognition of the EU trademarks that had been already registered in the UK. And there's a lot of talk about how pending applications in the EU will be treated in the UK. But your best bet is, if you're just starting out on your application in the EU, is to file both EU and UK separately and make sure that your brand is protected in both. Christian Christensen asked me on Quora, are trademarks a one-time registration thing? How often do you have to reapply for a trademark? Well, first of all, trademarks are the only type of intellectual property that in theory can last forever. This is how Coca-Cola has been renewing their trademark all the way back from 1892. Okay? They don't file new applications for the same thing. They just renew the same application. The other cool thing about trademarks is that there are no annual maintenance fees. Once you get it for 10 years. And then you renew it in another 10 years, and then in another 10 years, and then in another 10 years. And like I said, you would keep renewing them for as long as you're interested in that brand. So when my clients ask me about renewals, I always say, look, if you've been in business for that long, well, when it comes time for you to renew your trademark, renewing costs would be the least of your concern. Steve Melnick asked me on Quora, why do logos sometimes have the circle R or TM next to them and sometimes not? When is it necessary? It's never necessary. There is no requirement for you to display either the R in a circle or TM next to your logo. It could be a good idea though, because a TM means you're showing to the world that you yourself think it's your trademark. That's all it means. It doesn't mean it's registered. It doesn't mean that you ask somebody's permission. You just put a TM next to it. It could be a pending trademark application, but it doesn't have to be. An R in a circle means you think it's a trademark and the government agrees to give you the legal tools to enforce it against anybody else who'd be dumb enough to try to rip you off and use the same or similar brand for the same or similar products and services. Now, R in a circle means a registered trademark, TM means an unregistered trademark. And you putting it next to your logo simply provides notice to the world that you are claiming this brand as your own. But you are not required to do that. You may not give this notice to the world, and it doesn't mean you don't own the rights that you otherwise would in connection with that logo. So some companies choose not to do this, some choose to do this, and it really depends on a number of factors. Design is one of those factors, understanding of what this notice, what significance this notice may have from the legal standpoint. Also, there's this trend lately, some companies are almost ashamed that they own something valuable, and they want to be perceived as if they're closer to the masses, so they don't do that kind of stuff. But if you want my advice, if you've come up with a great brand, if you've taken the steps to protect it, it only makes sense for you to tell the world, this is mine. And that's what you accomplish by putting that R in a circle symbol next to your brand. Ava Fields asked me on Quora, is it legal for manufacturers to copy logos and make replicas? No, that's kind of the whole reason why trademarks exist, to make sure that nobody can take your name, take your logo, take your slogan, take your tagline, and slap it on their replicas, slap it on their products. It's kind of the whole purpose of you being able to take your brand or whatever brand elements you consider valuable and protect it against such unauthorized copying. So with very few exceptions, which I'm not going to mention, the answer to this question is no, you can't copy somebody else's logo and make replicas of their products. Liam Anderson asked me on Quora, what are some things to consider when selecting a business name and logo? Alright, there's really three things to consider. The first one is this name or is this logo memorable? Is it something that people can remember? Because if it isn't, you're going to end up with a worthless name or a worthless logo. The second thing to consider is whether you can get a domain name that's going to reflect the name. Because again, if you came up with a name and you can't get a domain name for it, it might be an issue. And the third thing to consider is whether or not you can use it, whether you can trademark it, whether you can own it. Because again, there's no point in spending $1 or a minute of your life trying to build a brand you can't own. So what you want to do, make sure that the name is memorable or the logo is memorable. Make sure you can get a domain name to represent the brand, and make sure that the name is trademarkable. And if it is, trademark it as soon as possible. The investment in protecting your brand is negligible compared to the possible reward if your business actually gets somewhere. That's the right way to do it. That's how all successful businesses did it. Rohit Singha asked me on Quora, what is the difference between copyright, trademark, and patent? Well, you can write a book about the differences between different types of intellectual property. Actually, I have written a best-selling book on that. But if I was to summarize this really briefly, patents are all about protecting the underlying idea behind an invention. You came up with a new product, a new process, a new method, something revolutionary that had not existed before, and something that wasn't obvious because of all the other things that had existed before. So you came up with that, and if you get a patent, you'd protect the actual invention, the underlying idea behind what's new and novel and useful around your invention. Copyright is all about content. Your books, your videos, your music, your software, your art, your photographs, your videos, content, right? The stuff that has value in and of itself. It's a good song, it's a good book, it's a good whatever, right? That's copyright. And trademarks are about identifying brands. So identifying products and services. The function of a trademark is to allow the public to tell your products and services apart from identical products and services of everyone else, right? There's a little bit of an overlap sometimes between copyright and trademarks when it comes to logos, because they're also images. But the copyright part of the logo protects the image itself, right? It's a beautiful picture that somebody designed. They own just the picture if they own copyright. But the trademark side of a logo protects not just the looks of the image, it protects the mental link between that image and particular products and services that the owner of the trademark offers to the world. Shaun T asks me on Quora, what is the difference between a trademark, a registered mark, and a service mark? All right, let's start with service mark versus trademark. It's the same thing. There used to be a time when trademarks only protected brands with respect to physical products, and service marks protected brands with respect to services. And for a long time, trademarks now cover both brands that cover products and brands that cover services. In fact, many trademarks allow you to protect one brand for both products and services at the same time. So really today the term service mark does not have a specific legal meaning, and there's absolutely no good reason to use it. You can't just use the term trademark and you'll be good. Now, the difference between trademark and a registered mark is in the status of a trademark, because in North America and Canada and US and a few other countries around the world, vast minority of countries, there is such a notion as unregistered trademarks or common law trademarks, where you get some protection for your brand by virtue of you using the brand so that a substantial number of people know about your products and services under that brand. So that's sometimes referred to as an unregistered trademark or just a trademark. Now contrast that with a registered trademark, which is you have a brand that you formally apply to trademark with the government trademarks office, and they say yes, you get a trademark registration certificate. And what that means is that when you say, well, I have a trademark, that not only you think you have a trademark, but you think it's a trademark and the government agreed to give you the legal tools to enforce that trademark against anybody else who might be dumb enough to try to steal it from you. So in theory, a trademark, a service mark, and a registered mark would all relate to the same thing, to the same brand. And a trademark could be a registered, in which case it's a registered mark or a registered trademark, and it can cover a brand in respect to not just physical products, but also services. Now, I hope this answers Shaun's question, and if you found this video interesting or useful, subscribe now, get notified whenever the next one goes live. And if you've got a question about trademarks, post it in the comments below. And who knows, I might feature that pretty soon. Until then, I'll see you in the next video.